Good evening, everyone. I am delighted to welcome you all for this class on DPIA and its significance in ensuring data protection and privacy compliance. In today's digital landscape, safeguarding data is paramount, and data protection impact assessments play an important role in this practice. Today, we will make an attempt to unravel the intricacies of DPIA and explore its critical importance in achieving data protection and privacy compliance. To this end, we have the honor of hosting Mr. Gaurav Goswami, an expert in the sector of data privacy, who will guide us through the essentials, providing valuable insights that empower us to navigate the evolving landscape of data privacy with confidence. Mr. Goswami is a data privacy and IP lawyer at Privy Law and an expert in the sector with experience as assistant professor in both University of Petroleum and Energy Studies as well as Campus Law Center, Delhi University. It is a pleasure to have you here with us, sir, and I look forward to an interesting and enlightening session. Thank you.
Thank you, Kashish, for the warm introduction. And first of all, I would say I'm not an expert. I am only an interested person. I mean, I would say no one can claim in India even that they have achieved this level of expertise in data protection as the law has recently developed, right? So I will start my presentation. The topic which you have given is you have asked me to provide give lecture on is DPIA, its significance in ensuring data protection and privacy compliance, right? So I will move to the concept of DPIA, what DPIA is and its origin, its relevance, and how to conduct it, right? But before that, right, jumping on the DPIA, I would like to introduce everyone. I mean, what I will be discussing in today's lecture, that I will give a brief introduction to the GDPR, that is General Data Protection Regulations. Then, what are the principles of data protection? What is DPIA? How to conduct a DPIA? And everyone is aware that DPIA as a concept is provided under the GDPR, but recently Indian government has come up with the DPDP Act, right? So under Section 10 of our Act, there is a requirement of this data privacy impact assessment. Also, then the penalties which are provided under the GDPR and DPDP Act for non-compliance of the DPIA or other obligations which are asked under the law by the concerned persons, right? Then I have added one slide for the legal practice and developments in India, as everyone today is talking about the data privacy and artificial intelligence. So I have made one slide like for the data privacy practice and how it is developing in India, right? So first of all, I will go with the what GDPR is, right? So the thing is the GDPR. It is a regulation developed in European Union, right? It provides for it's a legal framework, and that sets out the guidelines for the collection and processing of personal data from individuals, right? So they so the individuals in European Union, if their data is being collected, right, we do use the term processed, then you have to follow the GDPR. All the member states of European Union, they have to comply with the GDPR. Now, why the GDPR? I mean, what is the requirement? Why does they have to come up with a law, right? So the thing is, I mean, everyone has heard the term that the data is a new oil, and you must have seen that earlier in the industrial age. I mean, they used to run machines, and machines were run on the oil. So today the business and the industry has changed, right? So you see the businesses on internet, Facebook, Instagram, YouTube, and other platforms, they all, how they run. I mean, the main revenue source for them is the advertisements, I will say. So for them, the oil is to run their platforms is the data, right? So the government is also, I mean, aware that the importance of these industries. I mean, the online industry, which has, I mean, we have entered the digital economy right now. So the challenge before the government was there was a conflict of interest. I would say conflict of interest in manner like there are individuals like you and me whose data is being used by these giants, by the industry, right? Software industry, or these those who are available online, or other. I mean, I will mention healthcare and other who collect the data. So there is one. one party, that is the individuals like us, those whose data is being used. Apart from that, the other party is the industry, right? So there's a conflict of private interest and the public interest, the individuals whose data is being collected, and the private interest of the giants or the industry, right? Those who want the data. So the conflict is that the persons, individual, they do not want to share data. We have our claim to privacy, that we are saying that we have the fundamental right of privacy. We do not want to share our data, right, without consent. How you can use the data? And the other, on the opposite party, I mean the private interest of the industrial, Facebook and other, those who run their business solely on the data that they collect. So there was a conflict, one party saying we do not want to share, other party says that we need it. Now the government is there to resolve this, right? So how come, I mean, how come government can do it? So they came up with a balancing act, balancing law, right? So what this regulation GDPR does, ki okay, we understand the government says we understand the conflict. Now what we can do, that let's not restrict the movement of the personal data, right? Let's not restrict, right? Otherwise it will have the repercussion on the economy, isn't it? So if you restrict the data, everyone deny their data, then the industry, I mean digital economy, it will be a bane for them, right? So the government came up with what the that let's not restrict the data, but this free movement of data will be subject to certain qualification, or you have to follow certain regulation, right? You have to follow certain principle, you have to comply with certain guidelines, right? So that's with this act of GDPR, this regulation, they have come up with the balancing act. They this provide a balancing act. So now the data is freely movable, right? Its movement is not restricted, but subject to certain restrictions. So both the parties, private like individual, sorry, public like individuals like us, general, and the private, the industry, now they are both happy, right? So this act or GDPR, it's a balancing act which provides for the for balancing the interest of the balancing the conflict of the parties, right? So this is GD about the GDPR, its objectives. Now I will move further. Now when we talk about GDPR, I mean it start with its objects, subjects, territorial jurisdiction and all. Apart from that, then it talks about the definition. It provides for the parties who are actively engaged in this. So there are number of parties, those who are actively engaged with the GDPR. They are, I mean, data subject, data processor, data controller, supervisory authorities. These are the few, those who participate in the whole process of processing of the data, personal data of the individuals, right? Now after the definitions, this GDPR provide for the principles for data protection. Like whenever a data controller, he is processing any information, any personal data of an individual, they have to comply with these principles, they have to follow these principles. If they are not following it, they will be penalized, right? So the first one, if you can see, I mean, lawful fairness and transparency. Whenever any data controller, he is going for the processing of a personal data, he has to follow these principles. That is, the data should be only processed when there is a when you can provide for the lawfulness of it, right? The data should be fair, should be processed in a fair and transparent manner, right? So you have to comply with it. Then there is a other principle that is called purpose limitation. That is, the data shall only be collected for a specified, explicit and legitimate purpose only, not further processed in any manner that is compatible. So you when you ask the individual to provide their data, then you have to be very specific. You have to tell them that you have to provide them with this notice that for this purpose I am collecting your data and I will be using it for this purpose only. Then you cannot use that data for any other manner or any other purpose, right? So this is the purpose limitation. Apart from the data minimization, do not ask for the, I mean, if the requirement is only can be there, if the requirement is only of the name, do not collect the other data like what gender, about the religion. I mean, do not ask them. Keep the data only adequate level and the relevant data to be collected. This is the third principle for the data protection, right? Now, four other principles are also there. One is the accuracy, that the data, I mean the processor and the controller, he has to take care that the data he collects, they have to keep it up to date, and they have to take every reasonable step to make ensure the data is not inaccurate, right? This is also imposed upon the data controllers, right? Then storage limitation, you cannot keep the data for infinity, for infinite period, right? You have to delete the data, you have to you have to delete the data or dispose it after the purpose has been I mean it has fulfilled its purpose, right? So you have to delete the data, you have to dispose it, right? Right. So next is the integrity and confidentiality. While during the whole process of the data processing, you have to maintain the integrity and the confidentiality. You have to take care, the processor, oh sorry, the controller will have to take care that who all will get the hand on the this data, the personal data that has been collected for the processing. They have to take every measure to keep it confidential. Not it should not be like it's lying in the office open to everyone, anyone can check it out and anyone can share with it anyone. So you have to come up with a with certain policy or certain documentation that maintains the confidentiality and integrity of the data. Now, the most important for the purpose of this DPIA, I would say the accountability. Now, this GDPR has made the controllers accountable, that you have to follow or you have to comply with these principle. And if you're not complying, I mean not only the requirement is not only of the compliance, you have to demonstrate. If you are saying that we are complying with certain document, you have prepared certain document and you say that we are compliant with the GDPR, no. When there is a complaint or if there is a requirement by the supervisory authority, then you have to demonstrate. If they ask you that how you are going I mean how you are following the principle of integrity and confidentiality, you cannot show only the document, you have to take them through the every step which you are doing for keeping the documents or the data's integrity and confidentiality. So the requirement is demonstration, that requires the actively, you have to actively and continuously you have to keep the data, I mean you have to keep the data in consonance with the principles which are provided in the data protection, right? Now this is the introduction of GDPR, like why GDPR, right? What are the principles of GDPR? Now I'll move further. Now, this is why we came up with the GDPI. If you look at it, this is what happened in the recent, like I would say, 5 to 10 years. On internet, you go in the shops, you go, they ask for you. I mean, what's when is your birthday? We will be giving you 5%, 10% off. And what's your number, email ID, married, not married, and everything. So I mean, from this point, we thought of when we started receiving unsolicited messages, calls from these people, that I even we haven't shared it with anyone, but still, I mean, the data is being surfaced at various platforms, right? So this is one I mean, this one cartoon is to tell you the how the problem must have started, right? You provide something, they ask for more. So yes, moving further. Now, when we have talked about the objectives of GDPR, why, I mean, what GDPR does actually to the whole, I mean, European Union, then the principle which a data controller has to follow. Now, not only the principle has to be followed, there are responsibilities of the controller which are put up in a separate chapter under the GDPR, that the controller shall be responsible to do all of these activities which are put up on the slide. So GDPR, first of all, requires controller to implement appropriate technical and organizational measure to ensure and to be provided able to demonstrate. Now there are three things, right? You have to implement appropriate, not only organization, that there are requirement of technical and organizational measures. Now you have to implement them. Then you have to ensure and to be able to demonstrate that processing is performed in accordance. The requirement of the demonstration is very important under the article under the GDPR, right? So both technical and organizational, you have to take care of right? These measures shall be reviewed, and there is a requirement that you cannot say that in the starting or in the mid of the processing, you have come up with certain documentation, you have put up certain software, and you are done with the GDPR compliance. No, the measures shall be reviewed and updated whenever necessary, include the implementation of appropriate data protection policies by the controller, right? So it's a, I mean, data this compliance of GDPR or our DPDP Act, they are not like in the starting you have come up with a document and it's done. No, they are continuous purpose, continuous process, right? That has to be followed, and not only to be followed, it has to be demonstrated whenever asked. Otherwise they have put up the, I mean, large amount of fines on non-compliance, right? Now, apart from that, there is a concept of data protection by design and by default that is provided under Article 25. So these are by design and by default is, I mean, before the starting of, I mean, prevention is better than the cure, right? So before starting of this processing of the data, you have to come up with certain design. I mean, from the starting you have to do a privacy impact assessment, right? So all these things by default is you are putting in the system or the organization certain measures that protect the data. So that is data protection by design and default. Then you have to keep the ROPA, recordings of processing activity. You have to keep the records of every detail of the processing activity you have done with the data which you have collected, right, under Article 30. Security of processing, how you are what kind of security you are providing under Article 32. Then if there is any breach, then the data controller, he has been required to provide the notification of the data breach to the supervisory authority and to the individual in cases where there is a chance of high risk, right? Not only to the supervisory authority, the individual whose data has been breached, they have also be to be notified, but only in the case of the where there is a high risk of breach, I mean, high risk of harm that could be that can be caused, right? Now coming up to the data protection impact assessment, this all articles are put up in this one chapter only, that is the responsibilities and all. So we are coming up to the main topic, that is the data protection impact assessment, right? Now I will start with what DPIA is, how to conduct it, right? So moving further, now what is a DPIA? Now you see, now you must have seen that the this come under the chapter which asks the requirements from the controller which he has to follow. Now this is a process which has been imposed, I would say imposed upon the controller, that whenever, I mean, whenever they are coming up with a new technology, right, whenever they are coming up with a new project, and that project reflects that there is a high risk, that there is a high risk to the individual's freedom and its rights, then you must conduct a DPIA. So it's a process. What actually DPIA does is it is designed to discuss what you do in the process is, it you have to describe the processing, right? That what kind of processing you will be doing, what kind of data you will be collecting, in what manner you will be collecting. Then the assess the necessity and proportionality, necessity, whether I require more than this information, whether it is required. Then the proportionality, whether this much amount of large data of these much number of individuals is required or not. Then you have to design and describe all of this in the DPI process. Now what this do, what is the purpose? It helps to manage the risk, right? And which might occur because of the processing of the personal data. So DPI is actually a process that is conducted before the prior to the processing, and when there is a when you have come up with a new project, and there is a high risk which you think that there is, right? So you come up with a process, you follow it, and you come up with the findings, whether this will be, whether there is a there are chances of high risk, whether it will be harmful to the to the rights and the freedom of the individuals. So apart from that, you come up with I mean, I would say the DPI is an important tool for accountability also, that when the controller, if they conduct a DPI, they can surely show that yes, they have fulfilled the requirement of accountability, right? So this is about what DPIA is. I mean, not the technical term. We will be looking at Article 35 of the GDPR, which which provides for the concept of DPIA. I will move further. So now this is the Article 35, which provides for the DPI under the GDPR. So what it says, where there is a type of processing in which particular using new technologies, and after taking account in the nature, scope, and context, there is a likelihood. Now there is an, I mean, not for sure. There should be a high risk, even if there is a likelihood of high risk to the rights and freedom of the controller shall, prior to the processing, which I mentioned earlier when I was talking about the what is DPI, carry out an assessment of the impact of the envisaged processing operation on the protection of personal data. Now, I think this is clear that when a DPIA to be conducted and what DPIA is. I will get into the detail in further slides. Now, while conducting the DPIA under Article 35, it is required, the article requires that while conducting the DPIA, the controller shall seek the advice of the DPO. So the DPO, Data Protection Officer, shall be consulted whenever the controller is carrying out any DPIA, right? This is what section Article 35 of GDPR provides for. I will there is a there is a continuous part to it. I am moving to that. So I would say that has been mandated, right? DPIA is mandated where is a likelihood of result of high risk to the rights and freedom of the natural persons. It has been mandated. So I mean, this is a must compliance, right? So the GDPR, in the GDPR, when you read Article 35 itself, it provides for certain examples, and when you have to conduct what you can say, I mean, how you decide that there is a likelihood of high risk, right? So it has provided certain examples in the Article 35 itself. Apart from that, there are guidelines available on the website of EDPP. So you can also check that also, right? 2017 they came up with those guidelines in which they have pointed out that all these will fall within the ambit of processing that fall within the ambit of high risk, right? So three are mentioned in the this GDPR. First of all, them, when you are conducting a systematic and extensive evaluation of personal aspect, you are going after the gender, religion, sexual orientation, and all those things, right? And race, religion, and you are automated processing it, right? You have collected data related to all those things which I have mentioned, the personal aspect of an individual, then you are automatically processing it. And you this include the profiling. Profiling is means separating out the individual, the data that has been collected, it has been profiled definitely, I mean, on the basis of religion, gender, color, race, and all those things, right? And this processing, profiling, this will produce legal effect concerning the natural person or similar significant, I mean, this if this processing where you have collected the data, the personal data of individual, if it will be causing a discrimination in employment, even one of the employment in admissions to the colleges and all, so this is considered as high risk, right? Processing on a large scale of spatial category, Article 9 provides for the sensitive data. That also, I mean, there's an overlap under both these, or personal data relating to criminal conviction. So this is all also can be called as a sensitive data. When you are dealing with the sensitive data, the GDPR assume it that it is likely to result in high risk. Then next is the when you are systematically monitoring of publicly accessible area on a large scale. So you have to do the DPIA when you are collecting data, systematically monitoring any data that is publicly accessible on a large scale, like CCTVs and all those things, right? So DPI has to be conducted when there is a high risk. What fall under the high risk? Article 35 provides for that this all fall within the high risk. High risk. I mean, example. These are the high risk example. So moving further, now I mean, the idea is yes, okay, DPIA is something. This is a process that has to be followed, right? And when it is to be conducted, right? Prior the processing of the personal data, and and when there is a chance likelihood of high risk to the individual's rights and freedom of individuals, right? Now what DPI must contain, what are we talking about? A software that will be conducting it? Are we talking about a document which will be creating what exactly it is, what it should contain, right? And how to conduct it? So the assessment which you are making under a DPIA, it must contain what? This all which is why which I have reproduced on the slide is contained in the Article 35 itself. So it says what it should contain: a systematic description of the envisaged processing operation. You will be describing the whole processing operation, that what kind of data you are collecting, from where you are collecting, all those things you have to. And then the purpose. First of all, you have to give the systematic description, then the purpose of the processing. Why do you why and what is the purpose of this processing, including applicable the legitimate interest pursued by the. Then in legitimate interest is whether you have taken the consent of the individual, whether there is a contract which has been signed between you and the individual whose data has been collected. So you have to provide all the details in the assessment. Now next is, first of all, you will describe it, you will tell the purpose, you will tell how and what are the legitimate interests, how you, why you are doing it and how you are doing it. Then an assessment of the necessity and proportionality. You will assess whether you are collecting the data that is sufficient enough, or you are going, I mean, you are collecting unnecessary data, or out of proportionate, which is not required for your main purpose. Then assessment of the risk, what could be the possible risk involved in this whole exercise of your data processing. Then how it might affect the rights and the freedoms of the data subject, right? Now apart from that, the fourth thing which you have to mention is the measures advisors to address the risk. You have to also mention the risk for this processing which you are undertaking, you are about to undertake, what kind of measures you are undertaking. So security measures, measures to protect the, all those things you have to mention in it, right? So we have talked about what is DPIA, when it is to be done, what DPIA must contain, right? So this is the what a DPIA must contain, right? Moving further. Now, okay, the idea is good that this way we have to conduct. This DPI means this is how it is to be conducted. When it is to be conducted? Let's say a DPI is conducted, and it has come up with the finding. The controller and the DPO, they have come up with the finding that the this does has the impact of. I mean, this will be highly. Uh, Impacting the rights and freedom of the individual. Then what has to be done? Now it is asked under the Article 36 of the GDPR that controller shall consult the supervisory authority prior to the processing, where the data protection impact assessment under Article 35 indicate that the processing would result in a high risk in the absence of measure taken by the controller to mitigate the risk. Whenever the controller finds out and come up with the finding that yes, there is a high risk, there would be a high risk in the absence if we do not take any measure, then they have to consult the supervisory authority. Now what supervisory authority will do? They will provide, they come in, right? They will come up with a written advice to the controller. The advice could be, I mean, they can take up certain step or certain measures to mitigate the risk, right? Apart from that, I mean, they can suggest this, or they can simply say, I mean, do not move further with this processing. I mean, it could be, I mean, more than what you have come up with the finding, right? So supervisory authority, they will come up with the written advice to the controller that whether to move further, and if they can move further with the processing, then what step they should take, right? And the supervisory authority, they might deny it, they might ask them to not to process the data in what in the area they have come up with, for the project they have come up with, right? So this is Article 36 which provides for this. Now, what are the benefits of conducting a DPIA? So, I mean, why to conduct a DPIA? Is it only I mean, it is a compliance which have been imposed upon the controller, or whether there are any benefits of it to the controller itself, right? At the first instance, when you see, you look at it like there is an imposition of certain conditions or the compliance on the individual, on the, sorry, data controllers, right? But I mean, there is a positive side to it also, right, of these compliance and all. So if I talk about conducting a DPI definitely improves the awareness of the data protection risk associated with the project. It is, first of all, it will not it is not for the individuals whose data is being processed. It is also for the good of the data controller, that he gets aware. I mean, he gets aware about the risk which are associated with the project. I mean, conducting this, I mean, take an example. If a data controller, without conducting a DPIA, right, and he collects the data and he process the data, and there is a breach later on, I mean, he will be charged heftily, he will be fined, right? I mean, so why not to take a step right before it, and to come and to save yourself from these fines, right? So it is for the benefit of the controller also, he can escape such situations, or right. So next is the to help the improve the design of the project. When you know, when you have conducted a DPIA, you know the shortcomings and the shortcomings of your project which you have designed, the new technology you are supposed to suppose you are about to use, right? So you can improve it before going into the collection of the data, and collection of the data, you can beforehand improve the design, right? So it gives you an opportunity also, that you can mitigate the risk beforehand, right? And further moving, ensure and demonstrate that organization complies with the GDPR. Yes, you will be able to avoid sanctions if you are, I mean, showing that you have conducted a DPIA, and you have, in case you have already communicated it with the consulted with the supervisory authority. So yes, it gives you on the checklist. It gives you a thumbs up that yes, you have you have done diligently, you have done your work, right? Moving further, inspire confidence in the public, right? People, I mean, the data, if it is be from the data subjects, when it is collected, they will be, I mean, they will have confidence, yes, that our data is being not been blindly is being collected and used, right? This data controller, or this individual, or this entity, they are taking these steps from the very first day. So they are also very safe, or I mean, they will be confident to share their data with you when you ask them even further, right? So that also improves your relationship with the data subjects, right? Now further moving is, sure, user are not at risk, right? So yes, there is a positive side for the data subject also, whose data is being collected. Further, it enables the organization to incorporate data protection by design into new projects. So before starting the collection and the collection of the data, and you can already incorporate that this concept of data protection by design that you have taken care of, right, which comes within the article 25 talk about of it. Now moving further is reducing the cost and disruption, obviously. I mean, later on you come up, you realize you have not conducted a DPI, and later on you came up with the shortcomings and the faults in your system, um, or the project which you have come up, which that at a later stage, after the disruption has caused, it will cause you a high cost, right? So you can get rid of all this by conducting a DPIA. So these are the benefits of conducting a DPIA. Moving further, so as everyone is aware that India has our country has also come up with the digital personal data protection act, right? This year only it has been passed, right? So whether the question is whether in India, in DPDP act, whether there is a requirement of conducting a DPIA. So yes, there is under section 10. Now the section 10, it talks about it does not directly talk about specifically like article 35 of GDPI. It specifically does not talk about the conduction of the DPIA. It provides for the significant data fiduciary. So What this section provide this that in India the data controller is the data fiduciary. Now here, I mean, the terms are different, right? So the data fiduciary is, I mean, those data fiduciary which deal in certain I mean, which those who process certain type of data, like which is of high risk, right? Which is a sensitive, which are dealing in the sensitive data, or which is in volume, and which is in huge volume, or which causes a risk to the right of data principle, which might have potential impact of sovereign or integrity of India. And these which I mentioned, risk to the electoral democracy, security of the state, and public order. So if a data fiduciary has come up with a project, or he is processing the data which might fall within all these, I mean, which might cause the risk to the electoral democracy in India, which might cause the disturbance to the public order, then they all will fall under the significant data fiduciary, not the regular data fiduciary. So the requirement of the DPIA and the DPDP Act of India is for the significant data fiduciaries only, which fall, which come up with the processing, which fall within this categories, right? Apart from that, the we have only have the act, and rules and regular rules are about to come. I mean, so the picture will be clear later when the government comes up with the rules to the DPDP Act, right? So I'll move further. Uh, so where under DPDP Act the DPI has been provided. So this significant data fiduciary, those who fall within the definition of significant data fiduciary, they are obliged to follow certain conditions, right? These are, they have to appoint a DPO, not other data fiduciary. It is not been asked them to, I mean, they have to mandatorily appoint a officer, but significant data fiduciary, they have to appoint a data protection officer. Apart from that, they have to appoint a independent data auditor. And if you read clause C, they have to undertake the following other measure, that is periodic data protection impact assessment. So we have to look at it here, that we have to notice is that the data protection impact assessment, it is not one time thing that you have, before starting it you have done it. It might require periodic, it might be required to continuously you have to do. Now I will give you an example. Let's say data fiduciary, that is equivalent to the data controller under GDPR. He comes up with a project in which he will be collecting data he will be processing data of certain patients, or some hospital, right, in a hospital. Now while conducting that study or that project, he asked those patients, he collected first initially who all these patients will be, then he conducted certain tests on them, right? Medical test, diagnostic test, and all those things. Now when the project started, there was one kind of data that already falling in the on the high risk, right? Apart from that, when you started doing your processing of data, you move further with your project, there's a secondary data that has come up and that has come up because of the test which you have conducted, right? So that is also, so then you will again we have to conduct a DPIA for that, because that is falling within the high risk, isn't it? So I mean, you can go up to article 35 anytime and look at when you have to conduct a DPIA. So if the data that has come up secondary, which has been generated after the processing is started, that is also to be on that data also there is requirement of conducting a DPIA, right? Now, apart from that, the conducting of DPIA, you have to conduct significant data fiduciary has to conduct periodic audit and such other measure consistent with the provisions of the act as may be prescribed. So, as may be prescribed, there will be rules which will come up, right? So, moving further, so there is one recent case. I mean, in 2020 or 2022, this Capios and Goran AB, they were charged 3.4 US million dollars and 2.9 million euros, and what they defaulted is. They defaulted in not conducting a DPA. They did not conducted a data protection impact assessment. So there is one case which I mentioned for your. purpose, right? Moving further, so what are the penalties if you are not conducting a DPIA under Article 35 under GDPR? So under GDPR non-compliance, if you are not following the principles which are envisaged under Article 6, that is of that the processing should be for lawfulness, fairness, and all those things, and data minimization and other principles. If you are not complying with all of it, you are not providing the ROPA, that is records of processing activities, you are not conducting a DPIA, then you can be the fine that then that could lead you to fine imposed by the supervisory authority, and that could be 2% of your total worldwide annual turnover, or the 10 million euros. So this is not a small amount for company, for the data controllers or the data fiduciaries. Now in India, what is how much they have put up is this range is between 50 crore to 250 crore. If you're not following, if you're not following the provisions of or the guidelines which are provided, or the compliance you are not following, then you can be charged in between 50 crore to 250 crore. And it is very interesting to note that the fines are very huge. If you look at India, our MSMEs, I mean, I look at this act as a, I mean, threat to the MSMEs also if they fail to comply, right? So this is about the penalties. Now, what I will do, I will share my screen with all of you, showing you one DPI template. So you can find the DPI templates on website of ICO, that is UK's Office for Data Protection, and other universities. I mean, you can go to the supervisory authorities of different countries or EPDP. You can find these templates for conducting of DPIA. I will show you one, right? But before that, okay, I will show you one. Just a second. So I believe this is one of the this is the template, right? So this is a sample DPIA template. This is an example. I mean, how to conduct a DPIA. So if you look at it, when we talked about Article under 35, when we looked at the requirements that what a DPIA must contain, so we saw that you have to, I mean, identify the requirements, how you will be conducting, what is the requirement. So step one, you have to identify the need for a DPA. You will ask the controller to explain you broadly what the project aim to achieve, what type of processing it involves. You may find it helpful to refer a link to the document such as project proposal, summarize, right? All these details to be filled up first thing. Now if you look at, describe the processing. How will you collect the data? How will you use it? How will you store it? When will you delete the data? Now if you look at these requirement, collect, use, store, and delete, they fall within the principles of data protection, right, under Article 6. What will be the source of data? Will you be sharing the data with anyone? So this is the second step, describing the processing, right? And what type of processing identifies is likely. I mean, when you are conducting a DPIA, you know, I mean, you only conduct when your processing hit by the any of the provision provided under Article 35, right? When, so you will mention that why do you think that your processing will involve high risk. Then you will describe it. Then you have to describe the scope of the processing. I mean, what is the nature of your data, whether it include the special category criminal offense, whether you are collecting the data of a child. So how you will be using it, how often you will be using it, how long will you keep it. So all these things are to be mentioned in the DPIA. Then describe the context of the processing, right? What is the nature of relationship with the individuals, how much control will they have, right? So whether you have sensitize the individual, those who are providing you the data, do they include any children or the vulnerable group. So all these things you have to describe. So under the DPIA, you have to put in the document everything you have to put in the document, right? It cannot be left it cannot be left, right. So moving further, describe the purpose of the processing, why you are doing this, what is the purpose, so what do you want to achieve, why, right, what is the intended effect on the individual. All these questions has to be answered or the put up by the data controller or data fiduciary in India. Now moving further, whether you are considering to consult with the relevant stakeholder. So there is an option, I mean they have to seek the individuals, though I mean you tell them that you are conducting all that you are providing, you sorry, you are collecting this data of theirs, right, and for these purposes, whether they have any doubt or they want to assist you in certain manner, or they have any opinion as to it, then you will put all those consultation in this consultation process part, right. Fourth, assess necessity and proportionality, right. So assess necessity and proportionality, whether why you, what is your lawful basis, why you are collecting, whether the consent has been given or it is coming through a contract, right. Does the processing actually achieve your purpose, right. So all these answer, what is the information will you give individual, how will you help to support their rights, what measure do you take to ensure processes. So all these things have to be put up. So these are, now identify and assess risk also. So describe the source of risk when you have collected all the information, right, how and when, why you want this data and how you will be processing, then you put it in a table, or I mean you assess it, you identify the risk on the basis of the information which you have collected, right. So you can put up like that, this you have identified as a risk, right, then you assess it whether it will be called the, it will cause the harm, whether the, what is the nature of overall harm, whether there is only a slight harm, whether there will be a several harm, whether there, what is the overall, I mean you will rank it by your own, whether what you think that low, medium or high, right. Identify measure to reduce, what you will be doing, right. If you have come up with certain challenge, that what kind of software, what kind of policy, what could be done to eliminate that risk, you will put it in the step 6, right. So this is the identifying the measures to reduce the risk. For the sign off and record outcome, what you think, I mean you have collected everything, you have assessed it, what's your final call, whether you will be moving with it, whether, and when, if you are not moving it with it, and if you're moving further with the processing, then what kind of precautions or the on the techniques you will be applying, right. So summary of DPO will be putting up a summary. So the comments will be, consultation which you have done with the stakeholders, you will put that also here. So this is the template which is available on the website of ICO, Information Commissioner's Office, UK, right. So this is the template. So that is all uh, about the conduction of DPIA. I am open to question. I will stop here then.
Thank you so much, sir. That was extremely insightful. Uh, can we wait a minute or two for the questions, if you don't mind?
No problem.
Thank you. So there's one question. What rights do individuals, data subjects, have under the GDPR? So I think you're mute.
Okay, am I audible now? Sorry.
Yes.
So I would say under the GDPR, if you look at chapter, there is a whole chapter from Article 12 to Article 23. There is a lot of rights which have been provided to the data subjects, like right to eraser, right to deletion, right to amending their data, right. So there's a number of rights which have been provided to the data subject under it. The data subject can ask the data controller to remove their data. The data subject can even request them to remove their data, amend or correct, right. So all these things have been provided. I mean, there's a whole chapter dedicated for the rights of the data subjects under GDPR.
Any other questions? You can just put them up in the comments. Any other questions? Uh, so I don't think there are any questions for now. But before we end, I would just like to thank you on behalf of me and the LawSikho team for your time and contribution to this project. It was quite valuable, and I'm sure all our current viewers and anybody who views this after this uh, will learn something that they'll keep with them forever. Thank you so much.
Thank you, no problem, and thank you for inviting me for the lecture. Thank you, Kashish.
Thank you so
I will take your leave, right?
Yeah, thank you. I'll just end the live stream.